Well, Lord, I probably won't be half an hour.
I beg your pardon?
I probably won't be half an hour.
Good.
I think I gave myself a little extra leeway.
Always better to be pessimistic and then cheer us up, yes.
But anyway, my Lords, I wanted to begin by referring to the two authorities of the Privy Council which were referred to by the Court of Appeal, the first of which in the bundle is Duffus, the Jamaican case.
Yes.
I just wanted to remind your Lordships of the Act which was relied on in support of the public duty. It's fairly briefly stated on page E385 as the National Water Commission Act of 1963.
Yes.
And its function was and is to supervise the provision of water supply services throughout Jamaica. Mr. Duffus's claim was if you like, a private claim for breach of contract for wrongful dismissal. And the board roundly rejected the proposition that took it outside the execution of the purpose of the National Water Commission Act. Now, my Lord, presumably, my learned friend would argue that it did, because the contract of employment was particular to Mr. Duffus, and only he could sue for wrongful dismissal. And the obligations of the respondents in that case were private owed to him and failed the correlation test or the direct execution test, however it's put. But as I say, the board roundly rejected the submission. The other case, that's all I want to say about that, I know your Lordships have the facts of it, is the New Zealand case, Vincent and Tauranga and the Tauranga Electric Power Board.
Yes.
Now, the Act in that case contained, I think, both the public duty and the limitation period in one statute. Established the Electric Power Boards Act, and the appellant was employed. Again, he brought his action for breach of contract or negligence arising on the same facts. The relevant passages at E573, and it's Lord Alness who refers to the as I say, just on the facts of the case, he was an electrician who was burned in the course of working on power lines, and he alleged a breach of his contract of employment, an implied term of his contract of employment, and also negligence, relying on the breach of a particular regulation. Now, in the judgment of the board at E574, Lord Alness says, their lordships cannot doubt that this is an action against the board for something done or omitted to be done in the execution or intended execution of the Act. And it's those words which, in my respectful submission, we are entitled to rely. The fact is that plainly the board considered that the employment and the breach of the contract of employment amounted to something which was done or not done or omitted to be done in the execution of the Electric Power Boards Act. It does bear some similarity to the allegations of the appellant in the present case of breach of the terms of her contract of employment. And we say that quite plainly this is something which can be described as done or omitted to be done in the intended execution of the Act. And my learned friend says that it is important to realise that the words of the New Zealand statute differ from the words of the Virgin Islands statute, but in this respect they are the same, because the action has to be for something done or omitted to be done in the execution or intended execution of the Act. And however one construes those words, in our respectful submission, they include the employment of nurses. And Lord, if I can just remind you
Yes.
of the words themselves.
Yes.
I set them out at the beginning of the respondent's written case,
Yes.
in paragraph 2.
Yes.
It cannot be suggested in our submission that this is not a claim brought in respect of an act done in pursuance or execution or intended execution of any act or ordinance, or of any public duty or authority, or of any alleged neglect or default in the execution of any such act, duty, or authority. Now, if we are right, and that the employment of nurses was a part of the public duty of the government, in our respectful submission, it can hardly be considered otherwise, then it is caught by the express words of the section, and it cannot be avoided as a matter of construction. Plainly, the failure to provide a safe system of work is a neglect or default in the provision of the employment. And the provision of the employment is a duty on the government under the Public Hospitals Act. My Lord Hodge said just before the break that he would be interested in the statutory authority of which the
You're relying on Section 3.
and I said I'm relying on Section 3. I thought it might be helpful for your lordships to be reminded of what the Court of Appeal said about this. There's one in paragraph 4 on E132. And it's describing the basis of the appeal from the judge. 3 principal grounds. The first is that the judge erred in holding that the Public Hospital Act did not address the employment of nurses, merely vested the hospital in the government. And the allegations in this case did not involve a duty in connection with the ownership or occupation of real property. The second is that the judge erred in finding that the management and control of the hospital was vested in the board and not the government, and any public duty arising under the Public Hospital Act belonged to the board, a separate legal entity, and not in the Crown, as Mrs. Alves' employer. The third is that the judge, having found that Mrs. Alves was a public officer, erred in holding that her employment was under a private contract of employment, so that the government owed a personal duty to her, and her employment did not engage the government's public duty. There is only one issue to be determined in this appeal. Does the limit, really only one issue to be determined in this appeal, does the limitation defence under the Act apply to public servants who are injured in the course of their employment due to the negligence of their employer? If the answer is yes, does Mrs. Alves' claim fail? It would appear by inference, and this is taken up again a little later in the judgment, that the Court of Appeal were content to accept that the duty arose under the Public Hospital Act. But in our submissions I've made already, it really matters very little if it was a public duty, if it was carried out, the employment was carried out by the government. Then it was the government who was discharging that part of the public duty. The second passage in the judgment I wanted to take the Lordships to is at paragraph 19. And this appears to me to confirm the Court of Appeal's finding, which I would suggest is justified, that the Act, because it's the only Act referred to, is the Public Hospitals Act. Applying the above authorities, the facts in this case, I conclude that the Act applied to Mrs. Alves' right to bring an action against the government. The act of negligence out of which Mrs. Alves' action arose, the providing of a defective bed to a hospital patient, was an act performed by the government in the direct execution of its duties to provide hospital services under the statute. The maintenance of the hospital and the carrying out of public function of providing health services is impossible without nurses. There is no significance in the fact that only Mrs. Alves could have brought the action in her case for breach of a duty of care owed to her as an employee. The same observation plainly would apply to both Duffus and the New Zealand case.
He goes on to suggest that a road user injured by negligence.
Well, I was going to come to that because it's something which has been raised by your lordships, and I noticed over the break that it was something which the Court of Appeal had considered as well. Where a road user is injured by the negligent driving of a government employee during the performance of his duties, the duty of care is similarly owed to the injured road user personally, and only that road user can bring an action for his injury. But if the driving by the government employee occurred while he was on duty within the meaning of Section 2 of the Act, the injured person must bring his claim within the limitation period. The principle applies equally to a Crown employee suing under her contract of employment. And we would respectfully submit that that's all correct.
It'd be rather, I mean, if every public employee suing for breach of contract or for personal injury occurring in the course of his employment, and every road traffic victim who is a third party is caught by the Act, it's not a very restrictive interpretation.
Well,
but you say that is the law?
yes. Well, my Lord, I see with respect,
no way of drawing a limit.
We see no way of getting out of the words of the statute themselves.
Yes.
This is, I say that the employment of nurses is a public duty. If it is a public duty, then the failure to provide a safe system of work is a neglect or default in the execution of such a duty. And so it's caught by the Act.
Can I just ask about the wording of the statute, Mr. Guthrie, just in case I've misunderstood it? Do you agree that they've left some words out? If you compare Section 2 with the 1890, if you open Section 2, which is on page 240, tab 2, page 240.
Yes.
If you were to compare it with the, the English prototype from 1893, you would
I hope we have that in the bundle.
Wait a minute.
253.
You would find that the words "in respect of" appear in line 1, 2, 3, 4 after public duty or authority or, and if you try and work out the grammar, they have to.
Unless the word "of" were substituted with "for."
Unless the word "or" is substituted by "for," yes. Or "for." Sorry, unless "for" is substituted for "of." Yeah.
Yes.
But in fact, the 1893 Act has the words "in respect of." So what you've got is an action commenced against any person for any act done in pursuance, and then various alternatives.
Yes.
1, of any act or ordinance. 2, of any public duty or authority, but not 3, of any alleged neglect or default. Doesn't make sense. It has to be an action in respect of an alleged neglect. I mean, do you agree with that, or have I got it wrong?
What you're putting to me is that the words "in respect of" might as well be in the British Virgin Islands.
They actually have to be to make sense of it.
Yes, well, I'm sorry, yes.
Or the "of" has to be a "for."
Yes. Well, I think I'm bound to agree with that.
That's all I wanted to know. Thank you very much.
Well, I think those are the points that I wish to make. Nothing has been said about a waiver either below or here. No. In fact, it was expressly disavowed below. I just wanted to make sure that...
All right, we're not going to go and decide against you on waiver, which you haven't been... hasn't even been argued.
Well,
At least speaking for
I
myself.
always think it's best to be,
Better safe than sorry. You never know what will happen.
if in doubt, yes.
Thank you very much. Thank you.
My Lord, that's all I had to say.
Thank you. That's very clear. Thank you very much. Stephen.
My Lords, can I just deal with one point that took us a little by surprise, and that is the suggestion that, in fact, no board has been appointed. I mean, all I can do is make it clear that that has never been any part of the government's case below. It may or may not be right, but we are simply unable to comment or assist the board in relation to that. I shouldn't want you to think that we accept it, because we simply don't know. Can I next just deal very briefly with, by way of some very brief comments, a number of cases to which Mr. Guthrie referred. The first, I'll take them in the order in which he referred to them, is Nelson at tab 19.
Yes.
The issue in that case was whether the assistant medical officers were entitled to the protection of the Act as officers of a public authority performing duties imposed on the authority, or whether they were to be regarded as independent contractors in my submission, and therefore not entitled. It simply doesn't touch the issues which arise in this appeal in my submission.
Yep.
Higgins, which you have at tab 16,
Yep.
that case in my submission is merely an example of the 1939 Act, 1939 because the 1893 Act was amended in 1939, applying in the case of negligent treatment. And again, the issue was whether the defendant doctor could claim the protection of the Act, which depended again on his status and relationship vis-à-vis the hospital. The next case that Mr. Guthrie referred to was Rozelle and Snowball at tab 21.
Yes.
The issue there was whether the duty under Section 3 of the National Health Service Act
Yes.
was limited to the provision of specialists or extended to treatment by those specialists, on which the entitlement of the defendant to claim the protection of the Act depended. And so again, with respect of no relevance or assistance to the determination of the present appeal. Then I think there are just two more. McManus at tab 18. That case concerned the appointment and removal of a medical officer.
Yes.
We see that from page 552.
Yes.
Which appointment and removal was expressly provided for by statute, and the removal was quite clearly done pursuant to the statute, and therefore the Act applied. Then I think the last of the old cases, English cases, was Compton at tab 10, my lords, which was a first instance decision. The thrust of the decision appearing at 383. But that case related to the terms of the claimant's employment and was directly referable, therefore, again, to the duty that the council had to appoint him, as I read the authority, not some other duty owed to him. So, my lords, very briefly, having identified what each of those cases was really about, none of them, in my respectful submission, throw any light on the issues which you have to consider, which are more obviously addressed in the two decisions, rather different decisions, of Bradford and Griffiths. Now, my lords, Griffiths, can I just observe, it's a very simple point that won't respect escape your lordship's attention, but it's an important point. it simply doesn't touch or consider the position of an employee. And that position is not only special or in a special category, if I can put it that way, because of, as I have submitted, the reciprocity of obligation that exists, which is not so in the cases of carriage and other cases that you've seen. But there is another point, and it's this, that employees, whoever they're employed by, public authorities or private employers, are all owed the duties with which we are here concerned, the admitted duties for which there were admitted breaches. And it can't sensibly be said that an act done in breach of those duties which are owed across the board to all employees is necessarily or must therefore be regarded as an act done in the execution of some public duty, because that would be to distinguish between the position of somebody who is coincidentally employed publicly and another type of employee.
In Griffiths,
What the Act does, isn't it?
Yes, it does. Exactly.
Well, my Lord,
The issue.
that depends, with respect, on what one makes of the wording of the Act.
Yeah, well, we come back to the point.
And then one comes back to the question of interpretation. But I mean,
Very.
my Lords, what Section 2 of the Act does, where it provides that any action, prosecution or other proceeding is commenced against any person for any act done in pursuance or execution or intended execution of any act, is simply to state that, not to provide the answer as to what amounts to that. Now, our submission, and I certainly don't want to revisit my submissions, is that the act done in this case, which the appellant complains of, is the provision of faulty work equipment, not employing her. And the relevant public duty was to employ nurses in order to satisfy the statutory purpose.
but I mean, in Griffiths and Jones, had it been a schoolmaster who had fallen rather than one of the invitees, you would say that the Act would not apply. Is that right?
By parity of reasoning, I think that would follow.
Yeah.
In the sense
And how do you fit-
sense that the duty, the public duty there, was the maintenance of the buildings for the statutory public purposes.
By the way,
running
what happens
the
to there, but
Well, but my Lord, that with respect is an important point. And the member of the public who attends, who has an accident which arises directly out of that failure. Now,
Yes,
I'm sorry, Mark.
sorry, I'm just trying to see how you fit this into the statutory wording. The Act, what one's looking at is what is the relevant Act. Now, one could say the Act is providing the building or inviting people to an exhibition. Those are evidently public functions, but I think Mr. Guthrie would say that a fortiori, if you actually your employment of the person in question is a public act,
Well, yes,
then that makes even more within the statute.
Well, my Lord, no,
You draw
with
a
respect,
distinction
because
between employing the person
I do.
and controlling the conditions of employment.
I do.
That's the essential
the
distinction.
relevant act vis-à-vis the employee is the provision of the work equipment for that discrete and particular purpose. The relevant act vis-à-vis the visiting member of the public is the maintenance of the building. They're simply different duties owed in different circumstances.
Yep.
And my Lords, if I'm right about that, the act done in this case has nothing to do with her employment for the public purpose. I mean, she may well be employed pursuant to a statutory duty, and indeed herself be acting in discharge of that duty on the part of the authority, and incidentally, if sued, could herself pray and aid the assistance of the act. But it doesn't follow from that, in my respectful submission, that any act done vis-à-vis her is caught. And the reasons for that, as I submitted this morning, are first, that you must give, with respect to restrictive interpretation, to the provision. Secondly, that the correlation test is not satisfied. And thirdly, nor in those circumstances was the act done in direct execution of any relevant duty for these purposes. And, my lords, on the first point, the restrictive interpretation point, I say with, not without some hesitation, but and with respect, that the test proposed by Lord Morn is a test which does risk not a restrictive reading of the statute, but actually leading to a very expansive reading of the statute. And that is effectively what Mr. Guthrie's submission, which amounts to there's a duty to employ nurses, and with that comes every duty owed to the nurse, likewise leads to the same expansive reading. My lords, I think the only other thing I wanted to say, that may even be it, my lords. Would your lordships just bear with me for one moment? Sorry. Just a reminder, yes. My learned friend, Mr. Carrington, reminds me that even in Lord Morn's speech, there is a reference to not interpreting it widely, for which I'm grateful.
Can I just ask you about Vincent?
Yes.
You say that it can be distinguished because the language is different. In what particular respect do you say that there's a significant difference?
My lords, I think when I took your lordships to it,
I think it was any act whatever, wasn't it?
it was any act whatever. It was the
emphatic.
appreciate Mr. Guthrie is relying upon the earlier words in execution of, but the point that I was seeking to make was that if one looks at
Any act or omission, whatever.
any act or omission, whatever, and it's even, it's made even plain, well, perhaps, no, it isn't, but examples given of that are any alleged irregularity, trespass, nuisance, or negligence, and then or for any act or omission, whatever.
Yes, 13. Thank you.
But the argument, the contrary argument, of course, is that it's all governed by in the execution or intended execution, etc., which takes you back.
Well, my lord, that's
Contrary argument would be to the Morm test.
Yes, that is, and that does take you back to the Morm test. But as your lordships will appreciate, I espouse the twin approach, if you like, in Bradford, the correlation and direct execution test. The only other point I've made, which is an obvious one, is that the board were not invited, well, they were invited to, but they declined to consider that line of authorities in the New Zealand case, precisely because of the amplitude of the section, and therefore the sort of question that's just been put to me by my Lord Kerr wasn't, in fact, addressed by the board in that case.
They swept aside, you
They
say.
did. Well, they did, and your lordships may see why they chose to do so. And that may not be an option that your lordships have in this case. My lords, those are my submissions.
Good. Thank you very much indeed.
Lord, just before we part, Lord Hughes did ask about other jurisdictions which might have Public Authorities Protection Act. Would you like us to look?
Well, it's quite apparent that there are some, Mr. Guthrie, so I don't think I really need to ask, unless anybody else wants to, for a detailed piece
We
of
know there are at
research.
least 3 or 4 anyway. Yeah.
Yes, thank you very much. And you can add Canada as a matter of interest.
Because of the industry precedents.
There is a case in the Supreme Court of Canada dealing with this. Yeah. Okay. Good. Well, thank you both very much for your submissions, which were very clear and concise. Thank you also to those who were involved in preparing the written cases, which we found very helpful. The board will take time to consider what advice they will humbly tender to Her Majesty. Court's now adjourned.